Good evening, everyone. Good evening and welcome. It is my great pleasure as Dean of Penn Law School to welcome this tremendous event, which is part of a tremendous week here at Penn Law, Public Interest Week, and welcome our honest guest, our honest and honored guest, Sherrilyn Ifill, who is a tremendous leader and litigator and strategist and public figure working for justice around the country and has been for some time. She's going to be more properly introduced in a few minutes by Layla Barre. But I will, it's just really my honor to help host this. It is part of a great public interest week. I want to thank all of the individuals involved, the tremendous staff and students involved with our Toll Public Interest Center, and we're going to celebrate more tomorrow night. But you've really put on a great week with so much happening. It is a time in our country when the import and the necessity of social justice lawyering and public interest lawyering has never been greater. We are really proud of the programs we're developing here. We're trying to do more. It's my biggest fundraising priority among, and it's a big priority among a number of students and staff. And what we do in this week every year is really celebrate what we're trying to do all year round and into the years of the future, which is really help you build your own careers in the public interest. And there's many models to do that. We're trying to muster support to help you do that. And one of the ways we bring is try to bring in really inspirational leading figures like Sherrilyn Ifill to speak with you as honorary fellows every year. So the notion of an honorary fellow at Penn Law, I actually didn't realize this, goes back all the way to 1965. Penn Law has designated an individual who comes in and reflects the highest ideals of service in the public interest. In more recent years, for the past 11 years, we have built this in as part of our public interest suite to have an honorary fellow in residence who comes and spends time in the midst of their very busy schedule. And I know just how busy your schedule is. You picked not exactly a quiet week to come visit us, or we picked. And the fact that you're here, and because I know you have to leave on a train for Washington, D.C. for some very, very, very important work tomorrow, the fact that you're here with us, we couldn't be more grateful. Anyway, with no further ado, I want to turn it over. I also want to thank Professor Dorothy Roberts for moderating the conversation, and one of our star 2L students, Toll Scholar, Layla Barre, to help further introduce the program. Layla.
The 2016 election has forced many in the United States to grapple with rapid and often terrifying change. Change in the way we perceive our immediate security and future. Change in the way we relate to and understand our responsibilities to each other. And change in the way community leaders must organize to ensure justice for all at a time when many laws we thought would never change are changing. We also are reflecting on change in the way we perceive our history as Black and brown activists continue our freedom struggle as our country reckons with what has not changed in the past 250 years. Seeking guidance in these turbulent times, I have often turned to one of my sources of self-care and inspiration, books and the radical, prophetic, Afrofuturistic writings of Octavia Butler. Octavia Butler's Parable of the Sower follows the journey of a young Black woman, Lauren Olamina, living in a dystopian future where the economy and environment have crashed due to corporate greed, and an organization with the slogan, "Make America Great Again," has taken over the government. As Lauren journeys through California to seek asylum, she forms a radical community and faith practice founded on the concepts of embracing and effecting transformative change, interdependence, and sustainability. The core mantra of this group is all that you touch, you change. All that you change changes you. The only lasting truth is change. God is change. By embracing change and radical community building to challenge a fascist state in the face of displacement, sexual violence, political suppression, and slavery, Lauren's journey serves as a profound example of the power of Black womanhood and how grounding oneself in one's history and community can help one understand their own power and be an agent of change in harrowing circumstances. We are truly fortunate that this type of radical work not only exists in books, but also in Ms. Sherrilyn Ifill and Professor Dorothy Roberts, who fully embody the leadership and resilience needed for positive change. Ms. Sherrilyn Ifill is the President and Director Counsel of the NAACP Legal Defense Fund. In this role, Ms. Ifill has been on the front line on the fight for justice for all and has led the LDF in numerous challenges to white supremacy, sexism, and other intersecting forms of oppression. Working to protect the economic security of Black families impacted by segregation and displacement, the LDF filed a Supreme Court amicus brief that challenged predatory foreclosure practices which exacerbate the racial wealth gap by threatening Black home ownership. Earlier this year, Ms. Ifill won a suit against HUD and Ben Carson, challenging the refusal to ensure that rent subsidies were adjusted according to the current cost of living. Ms. Ifill has also been a part of critical legal challenges to the mass incarceration of Black, Latinx, and poor people and discriminatory policing practices. In her role as professor at the University of Maryland Law School, Ms. Ifill founded one of the first legal clinics focusing on removing legal barriers to formerly incarcerated persons re-entering society. On Tuesday, the Legal Defense Fund filed another amicus brief challenging the practice of sentencing young people to life without parole. In addition, the LDF has advocated for policing practices that would eliminate gender bias in the investigation of sex crimes and ensure that young people and persons with disabilities are not disparately impacted by invasive search practices. Joining Ms. Ifill in conversation is Professor Dorothy Roberts, the George A. Weiss University Professor of Law and Sociology, and the Raymond Pace and Sadie Tanner Mossel Alexander Professor of Civil Rights. Professor Dorothy Roberts' groundbreaking activism and academic work has illuminated critical legal issues in reproductive health and justice, bioethics, and family law. The ongoing relevance of Professor Roberts' contribution to public policy and the legal world was brought into stark relief this summer when the issue of immigrant family separation came into the national spotlight. Professor Roberts has written and spoken extensively about the roots of family separation in the criminalization of Black womanhood through the child welfare and criminal justice systems. In addition, Professor Roberts has emphasized that the separation of immigrant families is the latest example of a pattern of the state dismantling Black, brown, and poor families throughout U.S. history, dating back to slavery. Please join me in welcoming Professor Roberts and Ms. Ifill.
Thank you so much, Leila Bari and Dean Ruger, for your welcome and introductions. I just have to reiterate that it is such a thrill to have you here. I really can't thank you enough. You do so much for justice in this country. You're at the forefront of the fights. I follow you as much as I can. Thank goodness you're on Twitter. And you know, when we invited you, we knew it was a long shot because you're so busy. You so graciously responded to my email right away. I was shocked and agreed to come. We had no idea that you would be in the midst of this battle
Me
at
either.
this moment. And the fact that you are still stuck with us it's amazing. It's amazing, and it, I think, speaks to your commitment to helping to bring up the next generation of public interest lawyers that we are going to depend on because this is a long, long struggle. So I just want to thank you so deeply for your being here. We're really all so grateful to you.
Well, thank you. I'm really thrilled that I was able to come, and you know, Dorothy, you're a scholar hero of mine, and love your work so much, and love your just accessibility and openness. And you know, it is strange to be here because there is so much going on. I did want to figure out how to make it work, and I think with Kenesha's help, we powered through today. We fit 3 days in 1 day, and hopefully I'll be able to come back at some point. I thought it was important because, you know, first of all, I do programming myself, and I just know how hard it is when people have to cancel programs, and scheduling is so difficult, and my life doesn't get any easier. So the idea that there would be some point in the future in which nothing would be happening and I could come just seemed impossible. So I thought I should just power through it.
Yeah.
But exactly as Professor Roberts said, it is just vital to me to, especially at this time in our country, encourage young people who have made the commitment and believe that they want to do social justice work and become civil rights and public interest lawyers to feel encouraged in that choice. You know, to feel that the choice that you've made is a noble one, is one that is absolutely essential for the saving of our democracy. There must be a generation of lawyers and activists who are committed to this work. And to see yourself, you know, playing a vital role in the time that you've been assigned to do this work. So just in the spirit of being able to encourage and one day retire, it's important to feel as though you are engaged in a kind of generational conversation about what this work is. You have to, you run your race super hard, and then you have to pass that baton, and there have to be people to pass it to. So.
Yes, I agree. The older I get, the more I feel a new mission in teaching, that I am passing on the baton to students like Leila Bari and so many others here to continue the work that you know, is becoming very tiring at this point.
But there's a relaxation in that. I hired a former student of mine at LDF, who's now our deputy director of policy.
Yeah.
And she was my student, my second year of teaching.
Yeah.
And when you see that you know that generations of civil rights lawyers are coming up and you know can take on that kind of role, it's very exciting.
It's super exciting. It's the most gratifying part of teaching or activism, is being able to inspire the next generation to continue the work. So in thinking about what we could discuss, there was such a broad range of issues because you and LDF intervene for us in so many types of social justice issues. Leila Bari mentioned a number of them, as did Dean Ruger: voter suppression, racial policing, profiling by police, and violence by police, fair housing litigation. You know, the list goes on and on of all these very vital issues that LDF takes on. And then I thought, but you know, the issue of the moment, the reason why you have to leave out of here early and get to DC is the Kavanaugh possible confirmation, which might occur this weekend, they're saying. How timely could that be? And his appointment, or potential appointment, his nomination, raises all of these issues because if he is appointed to the court, he may be the deciding vote on many of these issues. Certainly his vote will weigh in on all of these issues. And also the confirmation process itself has been so revealing about power arrangements in America, about the role of judges, about what makes a qualified judge, about democracy itself is at issue right now in these hearings. And so I thought let's take the time to talk about that. And so I wanted to talk about your insights about the confirmation hearings, your thoughts about what is at stake for the kinds of issues that LDF litigates about, and also some guidance that you might have for us for the future of the strategy of organizations like LDF and just ordinary people who are wondering, how do we move forward in a time that seems so dispiriting, where every tool that you used to be able to use seems as if either no one cares about it or it's being stripped away from us, the very legal mechanisms of achieving change. And so I wanted to pick your brain on all of that, what we could do in half an hour anyway. Maybe starting with the confirmation process, because I know from following you on Twitter and MSNBC and all that, you have been right up close and personal with the nitty-gritty of the process. And I wondered if you could tell us some insights that maybe everyone doesn't realize about it, what the process of confirming this potential justice on the U.S. Supreme Court has revealed to you about justice in America.
So, I'm glad that you talked about, the process, because in some ways, I was talking with students earlier about, our profession and what unites us in our profession. And very often in our profession, we disagree on the substance. Some people are, in favor of affirmative action and think that affirmative action is permitted by our Constitution. Some people do not. Some people think that various civil rights should be narrowed. Some people do not. We can disagree about the substance of any number of issues and cases. The thing that is supposed to unite us, at least I thought, was our commitment to process, a certain kind of process that we accept as being appropriate in a democracy. And to me, that's like not particularly a right-left thing. I know that there's right-left dimensions to it, without question, but that there is a commitment to process. And so one of the things I think that has been most revealing and alarming about this particular confirmation was the abandonment of process. And in some ways, that's the part I think that, because we're dealing with such weighty substantive issues, we haven't taken account of the damage that this is doing to us. Kennedy announced his retirement, I think, on June 25th. I was very clear long before Kavanaugh was nominated that I did not think we should be moving forward the confirmation of a Supreme Court justice at this time.
Yeah.
And my reasons were very clear. The Mueller investigation was in full steam. This is before Michael Cohen pled guilty. This is before Paul Manafort was found guilty. The President of the United States is potentially the subject of an ongoing federal investigation by the special counsel, the subject of various lawsuits in New York. Yeah. The President himself had made certain statements that implicated and suggested that the Supreme Court might have to weigh in on this litigation that he's been involved in, or this investigation, if litigation came out of it, fairly soon. He insisted that he could pardon himself. He questioned whether he needed to honor any subpoena. He'd said a number of things that raised issues that would likely go to the Supreme Court if they were to arise. And so my view was, at that time, we just didn't know what was going to happen with the Mueller investigation, and actually this was bad for the country. And in fact, my argument was that it was bad for the court. Yeah. Because I thought, if you nominate someone and they're confirmed, and then Mueller steps to the microphone, in September, we were thinking at the time, and reveals that the president is in fact the subject of this investigation, or in some way implicated. That we would have a president, and remember, the investigation is not about just financial crimes, it's about the election itself, and about potential illegal conduct in the campaign and in the election. So I felt like the legitimacy of the presidency is at stake, and this is not the time where, the reward for that should not be that you get to appoint 2 Supreme Court justices, and that would be, really an unfortunate posture to put whoever the nominee was in,
Right.
put them
That's
in that.
before you knew it was
Didn't
Kavanaugh.
know it was Kavanaugh.
Exactly.
So that was my view initially. The calculation across the board was that this was inevitable. The Democrats only have 49 senators, the Republicans have 51, and this kind of wasn't worth spending time on. Then Kavanaugh was nominated, and we did what we always do at the Legal Defense Fund. We always do a very detailed analysis of the record of any Supreme Court nominee, and we publish a report. We read everything they've ever written. We read all their speeches. We read all their writings. We delve deeply into their history and record, and then we produce a report about their civil rights record, and sometimes we oppose the nominee, sometimes we support the nominee, and sometimes we neither oppose nor support. We just put the report out there to be informative. We share the report with the public. We absolutely share it with the Senate Judiciary Committee because we want them to focus on civil rights questions and issues for the nominee. So we did that for Judge Kavanaugh. We actually had to accelerate it towards the end. We didn't think that it was possible to have the confirmation hearing for Judge Kavanaugh before October. And even that we thought would be difficult. Because Judge Kavanaugh had spent so much time working in the administration, he has a whole series of records that have to be produced, and the custodian of those records are the National Archives that has the records for President Bush's library, and since he was staff secretary to President Bush, the question was when you could get those records. The Democrats on the committee sought the full range of his records, which we believe to be about 1 million pages. The Republicans on the committee said you don't need all that, and they sought only 440,000, I think, pages of documents Chuck Grassley sought from the National Archives. The National Archives, Chuck Grassley is the chair of the committee, responded to the chair of the committee and said, we can't possibly get the 440,000 that you want until the end of October. So we felt like, okay, we've got a little bit of time. 3 days later, Chairman Grassley announced that the hearings would be held the day after Labor Day. So the idea that you would hold hearings before you could get the full record of the nominee is not something I have ever heard before in the more than 30 years that I have been observing Supreme Court confirmations. So already we knew now that we were in a weird process place that I think is deeply troubling. Who wants to feel that someone has not been fully vetted? You wouldn't do it for a professor here or for any job and so forth.
True.
So that was the first problem. And so we started to accelerate, obviously, the completion of our report so that it could be out before the hearing, which would be the day after Labor Day. My own view was that there was the need for speed was that they too were concerned about Robert Mueller stepping to the microphone and saying whatever he was going to say, and they wanted to make sure that they could make this confirmation happen before anything might forestall it. And then it just snowballed. It just became worse and worse. It was as though the raw power of this thing just began to grow, and the Republican majority on the committee just became, in my view, just almost brutish in the exercise of the power. So they decided that the committee hearing would be on September 4th. A week before the committee hearing, first of all, they assigned a private lawyer who had worked for the Bush administration to review the documents that were available and to decide which documents would be given to the committee and which would not. I've never heard of this happening before either, unless the person works for the White House. And so this individual was reviewing the documents. A week before the confirmation hearing, he sent a letter saying that 100,000 documents the White House was not allowing to go to the committee. So that now there were 100,000 documents the committee was not going to review. A week before the committee, a week before the hearing, the chair designated another set of documents that the committee actually had, he had, committee confidential. And the designation committee confidential means that they can't be shared with the public, which means you could not use them at a confirmation hearing. Committee confidential is a designation that has been used in the past. It is usually bipartisan. It's usually the chair of the committee and the ranking member look at documents together. They determine that there's some parts of it that are classified, or there's personally identifying information like social security numbers or something of that sort, and they redact the documents. That was not what was done this time. The chair himself unilaterally decided that certain documents would be committee confidential, and the entire document, the documents were not redacted. And then finally, the night before the hearing, the committee chair dumped 42,000 documents on the Democrats in the committee, and so September 4th arose with this. So that process was kind of pretty bad.
Yeah.
And so a lot of what you saw those first days of the committee, when the Democrats were insisting on the revealing of the committee confidential documents, that was Cory Booker saying, "I'm going to do this," even though
I remember that.
even though the penalty is the potential expulsion
Right.
from the Senate. I mean, that's the ultimate penalty for revealing documents deemed committee confidential is expulsion from the Senate.
Right.
And so, people who have decried the theatricality of his moment, I thought it was great,
Yeah.
I thought it deserved that, and I thought it was powerful that he was willing to make that stand. And he did reveal the documents, so he started to then drop the documents
Right.
every few hours. It was like, Beyonce CDs or something, and so we would look online and see the documents. And when you looked at the documents, and actually we submitted a supplemental report because there were some things about racial discrimination cases and so forth in the documents. But there was nothing about them that was classified. There was no personally identifying information. It was just documents that were unfavorable to Justice Kavanaugh that had been declared committee confidential. It was just a breach of the relationship, the bipartisanship, respect, and so forth. And so a lot of what you saw was about that. And the Democrats attempted to delay the hearing. And I watched the chair of the committee kind of blow through their own committee rules, Rule 4, that would have required a vote on the motion that was made by Senator Blumenthal to adjourn the committee. He refused to allow the vote. He refused to allow the vote because Senator Mike Crapo and Senator Lindsey Graham were not in the room yet, so he didn't have the votes. If he had held the vote, the Republicans would have lost.
Yeah.
So instead he just said, we have to be in executive session to have a vote, even though it doesn't say that anywhere in the rule. And the best part was, it's one of those surreal moments when Senator Blumenthal said, "Show me," to Senator Grassley, in Rule 4, where it says that we have to be in executive session to have a vote on a appropriately raised motion.
Right.
And Senator Grassley said, "Well, show me where it doesn't say that." It was like, dude, come on, So it was really quite astonishing to watch the Republicans on the committee just blow through all the guardrails that are, it's the rules, it's the process that joins us in an enterprise around law. And we're not going to agree on the substance, but the process piece is where, we should be fair, and it just was deeply unfair.
Yeah.
So they began to reveal some of the documents, and those documents began to reveal some of the credibility problems that Judge Kavanaugh entered last week's hearing with.
Right.
Documents that demonstrated, that had not been available in 2006, but demonstrated that when he testified before the committee in 2006 for his seat on the D.C. Circuit Court of Appeals, he had not told the truth about involvement that he had in the judicial confirmation of William Pryor to the 11th Circuit, of Charles Pickering, who was seeking a seat on the 5th Circuit Court of Appeals, questions about whether he had received emails that had been stolen from the Democrats about judicial confirmations. And so he was confronted with those documents. In my view, his testimony was impeached. We're lawyers, we know what it means to impeach a witness.
Right.
When you're shown the document and they ask you the question, did you have any reason to believe that these documents were not actually for your eyes? And, no, I just thought, this was all part of the process. Well, do you notice that the subject line of the document is spying? That the first line of the document is, we have a mole among the Democrats. I mean, this is what happened. And I was there in the room watching this in real time. And he's just saying, no, I thought this was, we talked on a bipartisan basis. So that was really very powerful. And I don't think it translated out to the public that this is actually what was happening. In the first hearings, I'm not talking about the hearing with Dr. Ford. I don't think it translated to the public that was happening, that he was being asked questions with documents. They had suspected that he had these emails. He had denied it in 2006, and now we had the documents, and he was essentially trying to blow past it. So this was, now we saw some of the testimony. I mean, we saw, there was an evening where he had written an op-ed in the Wall Street Journal about a case that he and Robert Bork wrote an amicus brief for, Rice versus Caetano, a case out of Hawaii involving an election system in which Native Hawaiians were kind of preferred in the voting system for to be trustees of resources and accounts that benefited Native Hawaiians. And he wrote an op-ed in the New York Times and in the Wall Street Journal, and he used words like that it was a racial spoil system. He talked about affirmative action being a racial spoil system. He talked about that system in Hawaii in words that use these buzzwords that we know, right? And when Kamala Harris asked him again in the first hearings, what did you mean, what's a racial spoil system? And he said, I'm sorry, I don't know what you're referring to. What do you, I don't know how to define that. So she defined it for him. And then she said, what did you mean when you wrote it? You wrote it. What did you mean when you wrote, when you said it?
Yeah.
And his answer was, I don't know what I could have been thinking of. So there was a lack of transparency, there was an evasiveness, there was misleading testimony. It was not pretty. It clearly was not translating out to the public that that's what was happening in that first hearing. But for those of us who saw it, we were kind of teed up for the second hearing.
Right. I think you're absolutely right that there wasn't a general sense that we're talking about a nominee who has lied under oath to the Senate Judiciary Committee while he was being confirmed as a judge, and also in terms of his answers to the committee during the hearing. That didn't translate, I think, to the general public.
It was frustrating to feel it.
It was frustrating, and I was alarmed by how little attention was paid to the kinds of shirking of the rules or really throwing them aside, doing the opposite of what the rules said were supposed to be done. The withholding of documents. These are really serious matters that didn't seem to have the weight that they should.
This is kind of interesting to me because I was annoyed, I would read accounts in the newspaper and, this is not all, but certain portions of our media are really interested in trying to suggest that there's balance on both sides, all the time. And so they were just not prepared to identify what was really happening, which was real. One side was actually not following the rules. When Justice Sotomayor was nominated for the Supreme Court, she had been on the court much longer than Kavanaugh has been on the court. She'd been on the court 16 years. And the Republicans, if I'm not mistaken, maybe it was led by Jeff Sessions, insisted on receiving the minutes of board meetings from an organization that she served on, the Puerto Rican Legal Defense Fund, which is now Latino Justice, an organization kind of created out of the Legal Defense Fund that I lead. And they wanted to get the board minutes. She'd served on the board of PERLDEF, the Puerto Rican Legal Defense Fund, from 1982, I want to say 1982 to 1996. She was nominated to the Supreme Court by Barack Obama in 2009. And they wanted to have the minutes of the board meetings. This is not an organization she led, she was a member of the board. Not a public organization, not government service. But you know what, the Democrats, they thought it was overreach, but they said, you know what, let's get the minutes. Whatever they want, they should get the documents that they feel they need to examine this nominee. When Elena Kagan was nominated to the Supreme Court, they wanted all of her emails from the time that she was in government, and all of the emails were provided. So it's not as though there wasn't a history, right, of this kind of probing and of people receiving the documents. And yet the way it was reported or the way it was presented, and some reporters were doing an excellent job, but it just didn't resonate in the public. And it's always difficult to get process issues to resonate in the public. But it isn't in the profession. And so I'm mostly disappointed by the failure of engagement and voices outside of the civil rights bar within the profession to what was very apparently this process deal that was happening that none of us would tolerate in litigation at all. If you got 42,000 documents the night before a trial, it would be on and popping. You would come before the court and you would be outraged, and right? I mean, you would never tolerate that, right?
That's right.
The documents were concealed that shouldn't be concealed, or that we learned that there were 100,000 pages of documents that were deemed to be privileged, but but we never saw a privilege log, right? There are things that we would know are outrageous. And yet you never heard the leaders of our profession standing up and saying, this is what we see and this is corrosive to the process. And I think that's what really disappointed me in the first part of the hearings, was the people who could have sounded the alarm that this was problematic. In the same way that the ABA sounded the alarm last week and said we have to have an FBI investigation, right? Didn't happen around the process stuff.
So that's just prior to the hearings with Christine Blasey Ford and then Judge Kavanaugh responding, when people started to pay attention to these kinds of lapses. What about that hearing? What do you think that hearing and the conflicting testimony, the way in which the Republicans on the Judiciary Committee, and we might add now President Trump, responded to it? I think many of us felt it was the power of elite white men on display and the disregard of survivors' testimonies on display, that it represented some deeper issues in America today.
Well, I think all of that, plus, again, a lot about our profession. So let's begin, first of all, with the decision by the Republicans on the committee to outsource their questioning
to the prosecutor.
To a prosecutor from Arizona, Miss Mitchell, I think her name was. So actually, when after the hearing, I have to say that one really stuck with me, was the idea that the Republicans on the committee, all men, there's never been a Republican woman sitting on the Senate Judiciary Committee, and you just got to live with who you are. That's your reality. But they didn't want to live with their reality. They didn't want to live with the optics of that reality. And so, they hired this woman to ask the questions. The landscaping of it, the men sitting in their seats, she sitting down in the well like the court stenographer.
Right.
I mean, this is a sitting
this is
prosecutor.
what it looked like.
If you want me to ask the questions, then move aside and let me get a seat up there where I can ask the questions like I'm supposed. If I'm going to be a shadow senator, make me a shadow senator, move your chairs over, right? But no, it was her sitting. And when you look at the pictures, she looks like the court stenographer.
Yeah, it's very true.
So she's down there, they're up there. And because we started out thinking that she was going to question Kavanaugh and Dr. Ford, right? Yeah. So the atmospherics are bad enough, but you did think she was going to question both of them.
Yeah.
The firing of her, in real time, essentially, when Kavanaugh begins testifying, actually takes the insult to a whole nother level.
Yeah.
Because it's like they're checked out for lady time. Lady time is like Dr. Ford's testifying.
Right.
We have a lady who's going to engage with her.
Right.
We're going to just sit here and be men. And then when Kavanaugh's testifying, it's like, okay, got it. Let's let the men. This is now man's work.
Right.
Let's get in here and get this done. That's literally what
happened.
happened. So
they took over.
So just leaving aside, I'm just commenting now, not as a lawyer, just watching how this unfolded. That's the message. That's the choreography that we saw. That was awful.
Yeah.
Absolutely awful.
Yeah.
There are moments in America when the truth is the truth. And there are moments when we are all watching the truth together. I was in middle school the first time Roots came on television. And, I watched it with my family. And let me tell you, it was a moment. People could say what they want to say now, but when it came on, it was, I went to integrated schools, and you went to school the next day, and people were like very careful, okay? Because it was powerful. We had never seen anything like that before. In fact, in the 70s, black people didn't even talk about being really descended from slaves. It was almost like an embarrassment about slavery, right? And Roots was really powerful. It was one of those moments in America where a lot of us are watching the same thing, and we're learning a truth about America, and it's real. The Anita Hill hearings, was that also.
Yeah.
There's no question that Dr. Ford's testimony was that.
Yeah.
You could not move while she was speaking. And, I think that it struck many of us in a very deep way. And sometimes there is a power of testimony, and those of you who are practicing trial lawyers know what I'm talking about, where there's a truth that just can't be denied, where there's a testimony that owns the room, where there's a testimony that it literally stops time. And it was like that. So I think there was genuine fear by the Republicans that the nomination was a wrap. And you know, by all reports, President Trump even said she was really credible. You know, he thought it was in trouble and he thought it was going down the tubes. You know, and then Kavanaugh comes out and, you know, makes his presentation. And it was also a moment for this country as well. The unleashed rage, the incoherence, the anger, the disrespect, the partisanship, there was a brutal quality to it. And I will give, if you believe you've been wrongly accused of something terrible, that you would be really angry. So I totally get that. Clarence Thomas was really angry. I mean, he came from the Clarence Thomas playbook of like, you come out and you show your anger.
It was mimicking it.
He was mimicking it.
See that he was coached.
But he took it to the next level.
Right.
Clarence Thomas was even controlled
Yeah.
because he was a black man and he knew you could be mad as you want to be, but you better get yourself together because you're not going to be able to just do whatever you want to do. So no woman would have been able to do it.
Yeah.
No person of color would have been able to behave in that way. But Kavanaugh did feel that he could, and the willingness to put that all on display, to be disrespectful to the senators, the moment when first, Ms. Mitchell, the attorney, is questioning him, and there's, and she's sadly leading him to a point in his calendar that is a little bit problematic.
July 1st, 1982.
Yeah, it's a little problematic when PJ and all the folks were
Yes,
at
exactly.
going to the party for brewskis.
Yes.
And so,
At
and
Timmy's
that's
house.
at Timmy's house,
Yeah.
and that's the moment when Lindsey Graham just loses it,
Yeah.
right? It's like, back to the male anger again, and Lindsey Graham shuts the whole thing down, right? We're not going to be using her anymore because we're in difficult territory.
Yeah.
So it was pretty awful. It was an awful feeling to watch. It was, but also I thought it was necessary to see.
Yeah.
I think we learned a lot.
It was very revealing, I think, of that sense of entitlement, because I understand what you're saying, that you would expect somebody who was falsely accused, who thought they were, pretending they were at any rate, to be angry. But he was angry about being denied easy access to the Supreme Court. That's what he was angry about. And that sense of entitlement, I think, is what many of us thought.
Yes, but also now I want to go back to just like the profession and who we are.
Yes.
Like there is a respect that we have to have for process, even when we know the outcome we want.
Yeah.
That's just that's your training as a lawyer does that to you. You just you become conscious of process in ways that you might not otherwise have been, and you defer to process in important ways.
Yeah.
And what I think we saw was his nothing about process mattered to him.
Right.
Like not even, I don't have to answer your question.
Exactly. Yeah.
Did you do this? I went to Yale. What? How is
Right.
that an answer? Right? I mean, it was like you don't understand who I am.
Or
Yeah.
did you do it?
Yeah.
Did you? Are you?
What about
do you?
you?
Have a
Did
drinking
you-
problem? That kind of.
I mean, it was what's having too much to drink, whatever is on the chart. Like, dude. So there was a disrespect
Yeah.
for the process, and then the kind of the left-wing conspiracy stuff. I mean, so thinking about a judge needing to be impartial. And I've written a lot about this, that our system of due process requires not only that our judges are actually impartial, but they also have to satisfy the appearance of impartiality. And the Supreme Court has said that because it's critical that people have confidence in the justice system and in judges. And so it's not about whether a judge is actually biased. If you seek to recuse a judge, for example, there is an actual bias statute, 144, that allows you to seek recusal. But there's also 455 that's about the appearance of impartiality. You're not saying the judge is actually biased, but you're saying a reasonable person would believe that this judge could not impartially decide this case. And it's grounded in due process. It's grounded in the 14th Amendment. It's grounded in that notion.
Yeah.
And yet the presentation that he put on just blew that away. And at the end of the day, you have to ask yourself, the institution is the Supreme Court. And essentially what you're showing is that you are not willing to put that institution ahead of your angers, your sense of aggrievement, your sense of betrayal, and yet you want to sit on the Supreme Court.
Right.
And that's what I saw. Leaving aside all of the absurd answers and so forth, it was that. It was also, you don't even hold the court in enough regard for this country as a democratic institution, one of the pillars of our democracy, that you want, if you really think you're going to end up sitting there and you want to sit there, there's only so much you can say, even in your own defense. I mean, if you've decided that you don't want to sit there, if you want to give the speech that says, and therefore I withdraw, you can do whatever you want, right? I get that one. That one is like, let's have at it.
Yeah.
But if you're staying in the process and you want to be confirmed, and you're going to someday be sitting on the court, then you care about the perception of the institution. And I didn't see that.
It was
at
the
all.
opposite. He said what goes around comes around. This is a left-wing conspiracy.
We were going to reap
And
the
what
whirlwind.
Exactly.
Whoa.
So that's stating that he's going to be biased against left-wing causes if he's appointed to the court. So now, given all that you've been saying about how process has been disregarded, the regular qualifications for even a justice of the U.S. Supreme Court disregarded, the process that he's being pushed through in this way without respect for some of the basic rules that people have agreed on, to even if they disagree on ideology or policy, how then do we move forward as public interest lawyers? So your organization has had a valiant history of changing norms in society, changing conditions in our society through litigation. And I think some of what you're telling us raises questions about the strategies that lawyers should use if the tools we've relied on to make this change have just been disregarded. So we don't have much time. So I would love for you to also give a message to students who are wondering, listening to all of this, what is the strategy to move forward, and a message about continuing the fight and how, some insights about how to do it in the future.
Imagine that it's 1948 and you're Thurgood Marshall. And you're doing strategic litigation, and the country is what the country is in 1948. We just get an executive order desegregating the military. Most of the South is segregated. Many parts of the North are segregated. There are still sundown towns. There's still lynching. And this is your trade, is that you are a civil rights lawyer. And I was sharing earlier in remarks for tomorrow night's event, Marshall in 1948 was the case when he challenged segregated education at University of Oklahoma Law School, Sipplewell versus Fisher. And when he tries that case, these are all the cases he's trying on the way to Brown, right? He's challenging segregation in law schools and graduate schools and so forth. So he ultimately wins that case in the United States Supreme Court. But when he's trying the case in Oklahoma, he tries the case, and at the end of the first day of trial, and I know this because I was writing a tribute to him after he passed away, and I called Ada Sipplewell to talk with her about what it was like to be Thurgood Marshall's client and in the courtroom with him. And she said at the end of the first day, they had this conversation, amusing conversation, because it had never occurred to them as they prepared to try this case that they wouldn't be able to eat in the cafeteria of the federal courthouse. And so, Marshall joked at the end of the day, and he said, well, tomorrow, I'll try the case and you bring the bologna sandwiches. So I was saying that that's who we are. Right? I mean, you have your eyes on the prize. It's not because it's all perfect. It's not because it's even fair to you. Right? Yeah. But you don't allow yourself to be captured by that. You have in mind your goal and you work that goal. And, you know, maybe we're much more thin-skinned today. I mean, I would probably march on Washington if I can't eat in the cafeteria. You know, I would probably turn that into a cause celeb. But I think we're always operating in a system that we know is not fair. That's why we are civil rights lawyers, because we know it's not fair.
Yeah.
And so we don't allow ourselves to become captured by that. We figure out what our goal is. What are we trying to get to? And we're doing it on behalf of other people, and that's what really helps us. That's why it's so important not to just be a crusading lawyer, but to make sure that you have clients. That's what my director counsel, when I was a young lawyer at the Legal Defense Fund, would always say to me, what do your clients say? To remind me that I know you think you're the smartest person in the room and you have this wonderful idea, but what do your clients say? So you need to, first of all, have clients. You need to make sure that you're being a lawyer, true lawyer, and working on behalf of somebody else, not just your own theory about the world. And then whatever is your goal, you know, you have to keep your eyes on that goal. And so we should be asking ourselves, in terms of what we saw, in terms of all the rules that were blown past and so forth, what's our role in this profession? And this is something, by the way, we have not been sufficiently attentive to. And that is our role in the ABA and our role on the Civil Procedure Rules Committee that creates the, you know, rules of litigation. How many of you are doing that? Like, are you monitoring it? Are you trying to get on the Rules Committee?
Right.
These are things we've kind of ignored. We've kind of just left that to somebody else while we do all the meat and potatoes and the crusading. Actually, there's an apparatus that we have to take responsibility for also, to hold the profession's feet to the fire. And so we're seeing the turnaround of the profession. We saw the, you know, the 1,700 law professors, you know, letter, and you were one of them. And, the letter from the ABA that I think was really influential in moving Murkowski, saying there has to be an FBI investigation, that the profession kind of started to wake up after the second hearings. I wish they had woken up before, but they started to wake up. So I think it's not all despair. I think it's actually people needed to see, look, the thing is, we're in a club. And there are people who think that if you went to Yale, you know, worked my butt off, didn't know anybody, even though my grandfather went, but whatever. You went to Yale, you worked in the Bush administration, you worked with Ken Starr, you clerked for Judge Kaczynski, you clerked for Justice Kennedy, you know, you sit on the DC circuit. The next stop is the Supreme Court. I mean, that's what people were telling us all summer. This is outrageous. He's the best on the list that the Federalist Society has. Why fight him? He's the best of it. Well, we just saw him last week. Did that look like the best?
That's the best.
So I'm just saying that we're in a club too, and we also take all these markers as being markers that mean you get to go to the next stage, right? You all graduate from Penn, and people just assume you get to go to the next stage because you graduated from Penn. That's why you're here, let's be honest. So we're part of it too, you know, we accept all these markers. We like the prestige. We like people thinking that we must be at a certain level because we did X, Y, and Z, because we clerked for this person, because we did that kind. But this exposes for us our own complicity, right, in those markers and in giving people a free pass and in not applying the rules to people simply because they have the credentials that that our profession has decided are the credentials, and that those of us who, even though we are crusader-minded and public interest-minded, kind of like having ourselves. So we have, you know, it's not just about saying over there, they've got it wrong, we do it. So I think that's, you know, where do we go from here is we take full responsibility, not only for our substantive work as public interest lawyers, but also for our leadership in the profession and demanding more of the profession that is true to the values that we have as public interest lawyers. And sometimes we don't do that. We act like we're operating separately from the profession. We are in a profession, and we have a powerful opportunity to influence that profession if we think that is our responsibility. So I think that's key and core. And then going forward, look, I don't know what's going to happen over the next 72 hours. I do not think this is a foregone conclusion. I didn't think it was in July, and I don't think it is now.
Good.
You know, if you know someone in Arizona who can call Jeff Flake, please do.
You're
But look, you really should call your senator. You know, you should call your senator. You should let your voice be heard. I mean, I keep telling people, I don't know what's going to happen. Maybe this is the end of the republic. Maybe 2020 will be like 1944, and we'll be picking through the rubble and rebuilding our democracy. I hope not. But at some point, somewhere in the future, people are going to ask you what you were doing in this moment. You know, so if you can't just call your senator and say, "Well, I called my senator," you know, I think you should. But it's not that the Supreme Court is entirely lost to us. And, you know, we talked about this in the faculty meeting today. There are areas of law where I think, or of civil rights law, where I think the Supreme Court will continue to be in play. I mean, you will need to prove intentional discrimination, no doubt. But I think there are areas we have to seriously worry about. There's no question that Roe is looking quite grim. And I really encourage people to understand that, you know, Roe goes along with, you know, goes along with the cases on contraception, which I think people don't understand, and so they need to understand that. So Roe, disparate impact, certainly under the Fair Housing Act, ECOA and other statutes, the Voting Rights Act, absolutely. Affirmative action, absolutely.
Yeah. So I'm going to pause there because I think we still have a little time.
Oh, questions.
For questions. A little time for questions, or a question maybe?
Yeah, sure.
One, two tops.
Yes, because we need to get your train.
No question.
But thank you. Thanks for that inspiration.
So many of the wonderful things LDF has accomplished over the years have been accomplished through the courts. What are your thoughts on the role of the courts in dealing with government endorsement of symbolic endorsement of white supremacy through monuments, statues, or flags, such as Mississippi's?
Well, that's a
Do the
great
courts have a
question.
role?
Say again, do courts have a role? Yeah, there's actually been some interesting 13th Amendment, you know, litigation. It hasn't gone very far, but in the last couple of years around the Confederate flag in Mississippi, and we, you know, people have been sending us the pleadings as they go through to try to find the right theory. This kind of is, I'm much more on the other side of this because I do write about and have written about what I think are the messages sent by what happens in the public space. And so I believe very strongly that, you know, Confederate monuments and the Confederate flag and so forth send a message and send a message of white supremacy that can be powerful and important and disempowering. What role do the courts have? Well, first of all, it would be great if these images were removed from the courts. So it would be great if the courts themselves were not sending the message. Whether there is litigation that can get at them, as I said, there have been some interesting ones that have been mostly plagued by standing problems. And so we'll see. We spent a lot of time with one of these cases actually last year. Your case, yeah, and trying to figure it out. And so we're like still, we're open, you know what I mean? We're open, we're looking to see, it is a problem, but you know, it's a problem in lots of our litigation.
Yeah.
You know, one of the things that's happened with the Trump administration is it's really stretched us. We've done, for example, a lot of like we're doing a lot of agency litigation, which is not, you know, APA was not our thing. We've done, you know, FACA, we filed all this FOIA litigation, which was not our thing. So we've had to just stretch ourselves. And I think in some ways, as lawyers, that's kind of the fun of this time, if there's fun to be had, is that we're really thinking creatively and having to learn areas of law that we did not think of as traditional civil rights laws. But when you have federal agencies that are engaging in discrimination and then withholding and concealing documents, you kind of have to know something about how to engage with agencies. So we're just learning as we go to try to be responsive to whatever we have to do.
The fundamental rules have changed
Yeah,
where the
they
heads
have.
of agencies are doing
They
the
have.
opposite of what
well,
the
I
agencies
said this.
were
Look,
created for.
we've sued 4 cabinet secretaries.
Yeah.
That's unheard of in LDF's history. I don't know that we've ever done that. We've sued Betsy DeVos, we've sued Ben Carson twice, we've sued Kristen Nielsen, head of Homeland Security. This is not part of LDF's history. We sue states and, you know, private companies and housing discrimination, employment discrimination. But now we're in a practice against the federal government. So just as a matter of resources, what it takes from us is really extraordinary. We're fighting on 3 fronts. It used to be 2 fronts. It was the private discrimination, state-sponsored discrimination were the 2, and the federal government was kind of your friend, you know?
Right.
Even when they were Republicans.
Yeah.
When I was a young lawyer at LDF, I'll say this really quick because I know I have to go, but I think it's important. No, because people think this is all partisan.
Yeah.
So from 1988 to 1993, I was litigating voting rights cases at LDF, and I was sharing with students I talked with earlier that the first case I filed was a case challenging the way judges are elected in Harris County, Texas. And the case, you know, I was 5 months pregnant at my trial, and I'm like 26 or 27, and the case, you know, I have my baby, the case goes to the Court of Appeals, I wean my daughters, I do my Fifth Circuit argument, I argue the case in bank. In 3 years, it's in the United States Supreme Court, right? I'm 3 years out of law school, I can't even argue the case. At least at that time, you had to be 5 years out of law school. So The case, makes its way through super quickly. I forgot what my point was. What was the question again? I forgot. I'm tired. I forgot where I was. Partisan. Okay. So this is the case. So it's in the Supreme Court, and
we count on the federal agencies a little bit.
No. This is even better.
Okay.
So there were two cases. One, my case from Houston, there's another case from Louisiana, and the Justice Department intervened in the Louisiana case. The cases are all consolidated. They're going up to Supreme Court together. I'm not arguing. The head of the Legal Defense Fund, Julius Chambers, is arguing. But we're all sitting around together with the Solicitor General talking about the argument because we're splitting the argument with the federal government because they've intervened in the case.
Right.
And, they're not saying everything we want them to say, but we're splitting the argument. It's cordial. It's going to work. And that Solicitor General was Ken Starr. So it's not as though every time there was a Republican administration, it meant that you were in a situation in which you were in opposition to them.
Yeah.
So what we're experiencing now is not just partisanship. No. That's the point of the story that I'm really glad I remembered. That it's not just partisanship.
Yeah.
This is something different, right? Nobody thinks that Ken Starr was not like a super Republican. He was, and is. This is different. And I did meet with Jeff Sessions once, and I met with him because we were co-counsel. We were co-counsel with the Department of Justice in our case challenging Texas's voter ID law. We're co-counsel with the Department of Justice in a whole set of desegregation cases that are still under consent decree in the South. And so I met with him with other civil rights leaders, and we had very strong concerns about where they were going to be around policing and some of the consent decrees that were imminent.
Yeah, right.
And so I did meet with him, and it was astonishing, just astonishing. I was brilliant, I will say.
I'm sure you were.
I really was. I mean, I laid it out, and it was comprehensive. It was, and it was fact-based, and it was, I talked about Baltimore and the consent, and I had the Baltimore commissioner wants the consent decree, I had all this stuff. But, it was clear he was impervious. I finished and he said, articulate,
Oh my God.
And then months later, they tried to get out of the Baltimore, policing consent decree, and we stayed up all night trying to do an emergency motion.
Yeah.
They essentially switched sides in our Texas voter ID case. So this is not normal. This is not partisanship. This is something else. And I think that's important for people to understand also, because talking about this as right, left, and Democrats and Republicans papers over what I think is a really powerful and fundamental threat to our democracy. Yeah. And we should all care about that. Yeah. And I credit some of the people, even on the right, who are writing about that and who know that that is the moment that we're in, that you're being fooled if you just think that this is about partisanship. Yes, I do think one party has been captured by some of these elements, but that's not the only thing that's happening, and we should be aware of that. And so my experience in that time period when you had to work with Republicans, and there was still, even then, a kind of understanding they were not the most robust and aggressive civil rights enforcers, in the Bush 1 administration, but they understood that that was a job. They had a civil rights division, and that was their job.
They weren't trying to destroy.
They weren't on the other side.
Rights.
But now you have a Justice Department that has filed a statement of interest on the side of students challenging affirmative action at Harvard, and has indicated that they are working with the Department of Justice to investigate a claim of challenging affirmative action at Yale. That's the Justice Department of the United States. Yeah. So this is alarming, and this is unprecedented. The Civil Rights Division of the Justice Department was created in 1957. Some of the most iconic photos that you've seen from the Civil Rights Movement is, Nicholas Katzenbach standing with the black student at the schoolhouse door, facing a Southern segregationist governor. That was the Department of Justice. John Doerr standing on a street in Mississippi, trying to keep the police from beating protesters. I mean, these are the images.
They would be blocking the doors today, and they are, figuratively. I have a feeling that you are going to miss your train to D.C.
Yes,
and we're counting on you to do something about it.
We're keeping you. Join me in thanks.
So thank you. Thank you so much. Oh, thanks so much. Oh, can't thank you enough.